Attorney General against Shannon Tyreck Rolle and 4 others.
Mr. Rowe.
My Lord, I appear with my learned friend Mr. Kirkland Mackey, Assistant Director of Legal Affairs at the Office of the Attorney General, on behalf of the appellant, and our learned friends Mr. Edward Fitzgerald, King's Counsel, assisted by our learned friends Mr. Damien Gomez, King's Counsel, who appears remotely, and present in court Ms. Daniela Waddop and Ms. Bridget Ward, all appear for the respondents. My Lord, as your Lordships know, of course, the issue in the case is one that can be shortly stated. What does Article 6 of the Constitution mean when it says that a person born in the Bahamas is born a citizen of the Bahamas if either of his parents is a citizen of the Bahamas? Does the word parents mean, as the Supreme Court in the Bahamas had formerly held, and as we submit, mother or father if married to the mother? Or does it mean, as the courts below held in the present case, albeit by majority in the Court of Appeal, and as our learned friends say it means, does it mean biological parents? That's the narrow issue, but of course, in the course of answering it, your Lordships will need to consider perhaps some broader points about the way in which questions like this fall to be addressed. My Lord, I will seek to summarize our argument in a series of 7 submissions or propositions. And if I may, I'd like to state them first and then come back to seeking to make them good one by one, but I hope fairly briefly. The first proposition is this. Whatever may be the position now, when the Constitution was made in 1973, there was a strong presumption that a reference to parents in a legal instrument concerning nationality was a reference to mother or father if married to the mother. It was, in other words, a term of art with that meaning. The second submission follows from that. We submit it follows from the first proposition that parents in Article 6 must be read as having the meaning we contend for, unless there is some good reason to read it differently. Three, there is nothing, we say, in the text of Chapter 2, the citizenship chapter, to supply any such reason. Indeed, the contrary is the case. Four, we submit there is no basis for construing Article 6 differently in the light of anything else elsewhere in the Constitution. That would be to overlook the fact that Article 6 is itself a provision of the Constitution. The fifth proposition is that there is, in case this be suggested, no basis for construing Article 6 differently in the light of any change in our understanding of the content of the word parents. That follows from the fact that parents, as used in nationality legislation, is a term of art. 6, we respectfully submit there's no basis for construing Article 6 differently than one otherwise would in the light of the international obligations of the Bahamas. Still less on the basis that to do so would be consistent with the momentum of international human rights law, to quote our learned friends. And lastly, seventhly, there are good reasons why any change in the understanding of what is meant by either of his parents needs to be made through the democratic process and not as a result of a process of judicial interpretation. And I should make clear, my Lord, before I plunge a little into the detail of each of those propositions, that the question before the board, as your lordships well know, but it's perhaps worth stating it on the record, just for the avoidance of any doubt, is a purely legal question, and we're not concerned with the merits or otherwise of the state of the existing law. The question is, what does the Constitution mean? And if it is to be changed, how should it be changed?
It's a purely legal question. It's a question of interpretation.
Yes.
There's a right or a wrong answer.
Yes. So, my Lord, the first proposition, whatever may be the position now, when the Constitution was made in 1973, there was a strong presumption that a reference to parents in a legal instrument concerning nationality was a term of art, meaning what we say it meant, mother or father if married to the mother. As your lordships will have picked up from the printed cases, in support of that proposition, we rely principally on the decision of the Judicial Committee in the Fisher case. Minister of Home Affairs against Fisher. That begins at page 709 in the electronic record. Now, your lordships will recall that that was a case where the nationality legislation, as it were, of Bermuda made it clear that the relevant children were not citizens. They were children who had been born to the mother out of wedlock, who had then moved to Bermuda with her, and she had then married a man who was content to treat them for all practical purposes as his children and the children of the family. And the question arose as to their rights in Bermuda. It was accepted in that case, there was no appeal against this conclusion by the Court of Appeal, that they were not, as it were, citizens of Bermuda. I say as it were because Bermuda is an overseas territory, but within the Bermuda legislation, at the level of ordinary legislation, they didn't qualify because they were de facto stepchildren, but that wasn't good enough. But the question arose, what about their rights under Section 11 of the Constitution? And it was necessary in that context to say something, therefore, about Section 11 deals with freedom of movement, I should have said. It was necessary in that context to say something about how Section 11 should be interpreted, but in order to do that, it was necessary to set it in context, and it's the setting in context that we rely upon particularly. And that necessitated the board looking at the way in which the word child had been construed in various types of legislation. And if I can ask the board to pick it up at electronic page 717. And what your lordships will see at about letter C is the submission for counsel for the appellant being summarised. Child prima facie means legitimate child. Departure from this only possible on the basis indicated in the words used by or Justice Vaughan Williams in an earlier case, the Woolwich Union case, or upon a basis indicated by Lord Tucker in the Galloway case. And that just between E and F is the passage in the opinion of Lord Wilberforce from which we get our first proposition, leaving aside those acts which use the word child apart from any relationship to anyone, in which case child means simply a young person. There is a great difference between acts concerned with succession to property, with settlement for the purposes of the poor law, with nationality, or with family matters such as custody of children. And then his lordship goes through each of those different categories and explains what the meaning of child usually is in those contexts. And so you see, first of all, cases concerned with the administration of the poor law, just below F. G, matrimonial law, which has increasingly diminished the separation of illegitimate from legitimate children by adoption of the concept child of the family. Going down to the next page, 718, or page 328 in the original report, just below letter A, matters of succession, and the same applies to the interpretation of wills and trust instruments. It's set out there what is meant. Child means legitimate child, firmly rooted in the common law. And then finally, at letter C, of relevance directly to the present case, nationality. In nationality acts which provide for acquisition of nationality by descent, the assumption is a strong one that child means legitimate child. And the fact that such acts often contain a definition to this effect and provide expressly for exceptions, for example, in favouring legitimate or legitimated or illegitimate children, does not detract from the strength of this rule. And it goes on, the court goes on to explain that that's the case in Bermuda in relation to the Bermuda Immigration and Protection Act, which was the quasi-nationality act that I referred to earlier. That's what led both courts below in that case to conclude that stepchild did not include the illegitimate child of a Bermudian man's wife. That case then goes on to talk about how the term child ought to be construed in Section 11 dealing with freedom of movement. And the board felt able, in that context, to adopt a broader definition of the term. But for the purposes of provisions about nationality, we respectfully submit the law is absolutely clear, and certainly was absolutely clear as of 1973. This is a case from 1979, where the legislature refers to child, it means, in the old-fashioned terminology, a lawful child, and consequently where it refers to parents, the legislature or whoever it is doing the enactment, it needn't be, we say it needn't be simply a legislature, it can be the Constitution itself, whoever's drafting that legal instrument. When referring to parents, is referring to parents who are married. So that's our first proposition.
Well, is it right, though, to apply, to treat constitutional provision as though it's just it's equivalent to a nationality act? I know you say this isn't concerned with freedom of movement, but it's still, they've chosen to make citizenship a constitutional matter, and shouldn't one apply then a constitutional interpretation rather than a more technical statutory interpretation?
Well, my Lord, I come on to address that in one of my later propositions, but in the short answer is that, of course, the fact that it's in a constitution could be relevant, I would, to some extent, I would accept the point that one doesn't necessarily look at it in exactly the same way, but one has to look at the text of the Constitution itself to see whether some different way of looking at the provision is justified. But the mere fact that it is in a constitution as opposed to in an act doesn't detract from my starting point, which is that in construing any enactment, one at least starts from the general understanding as to the meaning of a term. And if one is concerned with something which is a term of art when used in a particular context, then the presumption, indeed the strong presumption, just as in nationality acts, in my submission, is that it means what the term of art customarily means. It might be different if one were concerned, and I'll come on to deal with this in more detail later, but it might be different if one were concerned with a general term which is not a term of art. The obvious example is family. And there are cases, of course, about I think your Lordship looked at them about 10 years ago in a case about the Court of Protection. There are cases about what's meant by the word family in housing legislation, where it says that you can succeed to council house tenancy if you are part of a family of the deceased tenant. And in 1920, that meant husband or wife and children of that marriage. And gradually that
You
term
might say
changed
the
over time.
concept
But
of
that's,
parents is a similarly one that evolves with changing social values.
well, the difficulty with that point, my lord, is that it's not even in 1973 being used in its conventional sense. It's being used as a term of art in my submission. The point about it being a term of art is that it didn't have its ordinary meaning in 1973. If you'd asked in 1973, just as today in ordinary speech, what is meant by the legal expression illegitimate child, the answer is, well, it's a child whose parents aren't married or weren't married. And by definition, when you put it that way, you're using the term parents in a different way from the way the statute uses the term parents. Because a child, if you're applying a purely legal definition of the word parents, you can't logically say the sentence, a child whose parents weren't married. Not a child from a legal point of view. I accept that there are instances where legislation or indeed a constitution uses a broad term, or a term which has within it a series of possible contents, and that might change over time. I'll come back to a very helpful passage which explains this in another case, but this is not such a case.
You refer to Fisher, which deals with the concept of a child means legitimate child. And I was wondering how that plays out in relation to Article 6. So if you go to page 484, it's set out there.
Yes.
Because that refers to every person born in the Bahamas shall become a citizen at the date of his birth. Every person born in the Bahamas at the date of his birth is a child.
Yes.
And your proposition would mean that it could only be legitimate children. That it must mean legitimate children. And that would lead to the absurd result that you had two Bahamian nationals, child born in the Bahamas, and under your construction, that child would not be a Bahamian citizen.
Well, my lord, your lordship read the first part of Article 6, but not the critical words.
I'm concentrating on the first part, because your argument concentrates on the second part. But if you concentrate on the first part, the child there must be a reference to any child, because it would result in absurdity. And it would be inconsistent with Chapter 1 of the Constitution.
Well, my lord, one has to read Article 6, in my submission, as a whole. Every person born in the Bahamas, I agree, every person when they're born is, in ordinary speech, a child.
Yes,
of course.
But
whether you become a citizen at birth depends upon whether either of your parents are a citizen of the Bahamas, which turns you back to the question of what's meant by parents.
if you applied Fisher and Galloway, you wouldn't even have to go to the second part. You would just say the child's illegitimate, and it isn't being referred to.
Well, my lord, I'm not sure that I would concede the correctness of that. My submission would be that you need to look at the whole of Article 6, and it's not helpful for purposes of analysis to try to break it down quite so
Well, the
much
two
into
parts
different.
would be in conflict with each other.
Well, I'm not. I mean, the reference is to every person. It doesn't use. I agree. If it said. I suppose if it referred expressly to the term child, that would be bringing in the term of art of a child. It doesn't say that. But can I
That line of
develop the
argument,
point?
of course, gives a difficulty for you when we come to the point about it doesn't say father or mother either.
Well, I'll come on and deal with that in a moment. But But the starting point of my submission plainly must be that when the framers of the Constitution sat down to frame Article 6, they did so against the background of the very strong presumption that, rightly or wrongly, the very strong presumption that in drafting nationality provisions, any legal instrument about nationality, the
To rely on that
the
presumption,
term-
wouldn't they have used the word child?
no, my lord, not necessarily. They would have seen no need to, because to say that parents means parents who are married is merely the flip side of saying the definition of child is a person whose parents were married for the purposes of nationality legislation. That's how it's put expressly in Fisher, where it's explained that the consequence of the basic rule is about what's meant by child is that you read the expression parents in the same way. So my second proposition then is, if we're right about the first proposition, then
Just before you leave,
Yes.
I should just so I'm clear what the submission is, because, of course, Lord Wilberforce goes on to reject applying what he regards as the narrower approach in preference for the wider approach. Now, is your submission that that's because he was dealing with that part of the Constitution that doesn't define nationality, but is rather dealing with a consequence of the nationality, that is, the right to movement, and that he wouldn't have felt able to take the wider view had he been interpreting that part of the Constitution defining nationality? Is that the submission?
yes, my lord, essentially that's right.
Yes, thank you.
Because what you're concerned with in Fisher is, I mean, Your Lordship has the point, I'm sure, but what you're concerned with in Fisher is a case where you have somebody who is not a national, and that issue has been resolved by the courts below, and there's no further appeal to the court about it, is nevertheless saying that you can't remove me because that would infringe my rights under Section 11, which says no person shall be hindered in the enjoyment of his freedom of movement. And the Section 11 is set out at electronic 716. And you can see there that it sets out at one the initial proposition, and then there are exceptions in Section 2. Nothing contained, left by letter B, nothing containing or done under the authority of any law should be held to be inconsistent with or in contravention of this section, to the extent that the law in question makes provision for and then D, for the imposition of restrictions on the movement of or residence within Bermuda of any person who does not belong to Bermuda. And then there's a definition of what's belong to Bermuda means. And one of those, right at the end, is child of a person possessing Bermudian status.
Then I suppose the question that would then follow on was, why is one making such a distinction between different parts of the Constitution? Why should one, in a sense, be applying a more liberal approach to interpretation under parts of the Constitution, not others?
Because Section 11 of the Bermudian Constitution was not concerned with the definition of citizenship. It was concerned with the rights that should be had by people in Bermuda. And therefore it was legitimate to take a broader approach to that and to apply that more generously. But doing that did not cast any doubt on the proposition that the way in which you decided who were the, as it were, citizens of Bermuda, was a matter to be decided on conventional principles, looking at the legislation.
But then my question is, why?
Well, my lord, can I?
They're all parts of the Constitution.
They are, but my lord, the answer is in my submission, is to focus on our third proposition, which I'll come on to, which is that there's nothing in the text of Chapter 2 to supply any reason to adopt a different meaning of the term from the meaning that it would undoubtedly have if it were an expression in a conventional statute concerning nationality, where there was no supervening constitution. And so for that purpose, can I then go to the Constitution itself? That starts in the electronic bundle at page 551. We can pick up the text from 557. And I start there because that's the the provision about what the Constitution is, Article 2 in particular. This Constitution is the supreme law of the Commonwealth of the Bahamas, and the point I make about it in passing, it's this Constitution. It's not any particular part of the Constitution. So the whole thing is the supreme law of the Bahamas. That's relevant to a later proposition. That if we then go down to 558 and the provisions, we can see the scheme that the legislature has, or that the enactors of the framers of the Constitution, rather more accurately, have set out. And my overarching point about this is that the whole chapter is premised on the importance of marriage in its relation to citizenship, and more precisely the validity of the distinction between, in the old-fashioned terminology, legitimacy and illegitimacy. It's also striking in a case where your lordships are being asked to apply a more liberal and enlightened, as it were, construction of the Constitution. It's striking for its disregard of the idea of equality between the sexes. But rightly or wrongly, that's what the Constitution says. So if we go through it, if we may briefly, Section 3 is concerned with essentially natural-born citizens of the United Kingdom and colonies. Your lordships will recall that under the 1948 British Nationality Act, essentially the world was divided into citizens of the United Kingdom and colonies and aliens. And so everybody who had been born in the former colony of the Bahama Islands was, by virtue of that birth, a natural-born citizen of the United Kingdom and colonies. And Section 3.1 merely provides that they automatically become citizens of the Bahamas on Independence Day. Section 3.2 deals with people who are born outside, who were born outside the former colony. This is who had been born before independence outside the colony. They become citizens of the Bahamas and were CUKCs. They become citizens of the Bahamas if their fathers, if his father becomes, or would but for his death have become, a citizen in accordance with the preceding paragraph. So you immediately see the striking point that it's only fathers who are capable of capable of, as it were, conferring Bahamian citizenship on their children. That immediately sends you off to Article 14, or Section 14 rather, of the Constitution, because there's the word father. And Section 14, down at page 563, is the provision that says any reference, Section 14.1, any reference in this chapter to the father of a person shall, in relation to any person born out of wedlock other than a person legitimated before the 10th of July 73, Independence Day, be construed as a reference to the mother of that person. That's, I would submit, in a sense, a sort of concession in favour of the person who is in that situation, because on an ordinary reading of the provision, but for Article 14.1, Section 14.1, Section 3.2 simply wouldn't bite. A person who is born outside the former colony of the Bahama Islands to a biological father, but who isn't his father in the old-fashioned legal sense because the parents weren't married, can't benefit from 3.2, but can benefit from from Section 14.1. But we don't need to go into the implications of every single aspect of that, but the overarching point I take from it is the very striking importance that's placed by the framers of the Constitution on the concept of legitimacy. And then if we go on to Section 4, that's to do with people who were naturalized as citizens of the United Kingdom and colonies. Essentially, they too become citizens of the Bahamas, but they get a year to decide that they'd rather not. I suppose on the logic being, I suppose, that if you've taken the trouble to naturalize yourself as a citizen of the UK and colonies, you don't necessarily want to naturalize yourself as a citizen of the Bahamas. Then Section 5, persons entitled to be registered as citizens. That deals, that again is striking for, my learned friend's right, it is article in this Constitution, Article 5. That applies only to women who are or have been married to a person who becomes a citizen under Article 3. And what's striking about that and relevant to our case well, there's first of all the general point that it shows little concern with equality between the sexes, but even more pertinently, perhaps the emphasis is on marriage. It doesn't contemplate there any relationship short of marriage as being good enough for the purposes of Article 5. Then we get to Article 6, which is the first provision dealing with people born after independence, which of course is at the heart of the case.
I mean, there's a difference between rights given to women and to children, isn't there? Because the woman can choose or not to be married, but the child doesn't have any choice about whether their parents are married.
I agree, my lord, but I agree there's a difference. But I would contest any suggestion that it makes a relevant difference for the purposes of this case. But I accept that that's right as a general proposition. Then we get to Article 6 that we've looked at, so we don't need to go through that again, except to say that I respectfully submit there's nothing of any significance in the fact that the way it's worded, either of his parents, is like that, as opposed to being a different formulation such as mother or father or mother. I respectfully submit that the then Chief Justice who decided the K case, which I won't go to now, but is the former case under this provision, was quite right to say it was mere economy of language. And it's a more natural way of expressing it, either of his parents, but it doesn't tell you anything about what's meant by parents.
Isn't it curious that having gone to the lengths of qualifying the meaning of father, so that father bears a specialized meaning, they don't use the word father here?
My lord, in my submission, no, not particularly. It's simply the more natural way of expressing the point. It doesn't really get you any further, because who are either of his parents? Well, either of his parents are his mother or his father. But we know that in this context, the Constitution's framers have put importance on the notion of the father being the legitimate father in the old-fashioned terminology. So it doesn't, in my submission, it doesn't take matters any further forward.
I understand you to say that the words mean mother or father if the father is married to the mother. Is that right?
Yes.
Yeah. Or do you say that the words mean biological mother or father if the father is married to the mother?
Well, my lord, it depends what antithesis your lordship is drawing. What's the meaning of mother or father, other than biological mother or father, which your lordship has in mind?
Well, I've had in mind what Evans J.A. Articulated, which is set out at page 7.
I'm sorry, page?
Electronic page 7. Oh, sorry, 488, sorry, 488. Paragraph 31. Answering it that it was the relevant person's mother and her husband, if any, rather than his or her biological parents.
Yes. Well,
Do you support that proposition?
I think essentially I do. I mean, the way it generally proceeds, of course, as the common law proceeded, is that there's a presumption that the husband of the mother is the father of the child. I think I'm right in saying, well, I mean, if it's of great importance, we might need to do some more research on this and come back to your lordships. But I think it's right to say that the legal position has always been that is the presumption, though it could be displaced in a particular case. But what it doesn't mean, and this is my core of my submission, what either of his parents doesn't mean is either of his or her biological parents. And indeed, putting it that way, and this is my seventh proposition, I think, so I'll come to it in due course, but putting it that way actually gives rise to some really quite tricky policy issues that need to be looked at. What I'll seek to show under my last proposition is that actually when in the United Kingdom it was decided to do away with the notion of legitimacy as being important, or illegitimacy so-called, as being important in nationality law, the government had to make, well, Parliament had to make, and then the government had to make, because it was delegated to the government, policy decisions about what actually was meant by father. And actually the government changed its opinion about, changed its view about that and changed the law as to what was meant by father. There are significant problems in saying, oh, well, this just means biological father, or biological, or indeed actually biological mother. As I'll come on to show, there's actually a definition of what a biological mother is as well. Because in modern times, it doesn't necessarily mean that the person who carried you and gave birth to you is your genetic mother.
But if you're right in your starting point that the presumption is that child means legitimate child and parent means legitimate parent,
Yes.
Why doesn't this provision simply have the effect that anybody who's illegitimate can't benefit from it? Because they don't have any legitimate parents.
Well, my lord, that is the position. That is the position. The position is if you seek to say that you are a citizen of the Bahamas, then by virtue of having been born in the Bahamas, then the criterion you need to meet is having a parent in the strict old-fashioned nationality law sense who is a citizen of the Bahamas.
But I thought your case was that it worked only one way around, and that if your mother was a Bahamian citizen, you could get in this provision. Isn't that your case or not?
Despite being illegitimate.
Despite your being illegitimate.
Well, the case isn't the case itself isn't directly concerned with that issue.
No. Well, what is your answer to it though? Where the mother is a Bahamian citizen and the child is illegitimate.
Well, my lord, well, I'll be corrected if I'm wrong by my learned friend, but I think may I just have a word with my friend so I'm not misstating the position. Yeah, I thought that's right. No, we would accept that in that instance, the mother's unmarried status doesn't deprive the child of Bahamian citizenship.
Well, how does that work? If parents means legitimate parents.
Because
the mother
of the particular
parent than the father.
Because of the particular emphasis which the Constitution places on the importance of the father being married to the mother in order to qualify as the father.
Well, we see that. Rely on for that. Are you saying you somehow get that out of Article 14?
Well, Article 14 is only consistent with that as a position, my lord, because Article 14 makes special provision for what happens in the instance of a father of a person born out of wedlock. So it plainly emphasises
either the mother is no more a lawful parent within the meaning of Article 6 on your interpretation than the father. So it just brings you to the same problem.
Well, my lord,
it's all or nothing, isn't it?
Well, it's not the task of the board on this appeal to answer as a matter of law, as opposed to a matter of the practical position that's taken by the authorities in the Bahamas. The question as to what happens in the instance of a person who is born to an unmarried Bahamian citizen where the birth takes place in the Bahamas.
Well, we have to give a coherent interpretation of the provision.
My lord, that of course I accept. But there's a fundamental difference, for obvious practical reasons, which is no doubt why the common law historically drew the distinction between identifying who is somebody's mother and who is their father. Namely, that it's pretty straightforward to tell who the mother is, because it's leaving aside recent developments of assisted reproductive technology, which give rise to the issue I mentioned earlier. Leaving that aside, it's pretty obvious who the mother is. It's the person who gave birth to you. But in the case of the father, of course, historically that's not always been possible to know definitively until.
Do you say the common law rule that you rely on is asymmetrical? In that it's a different rule for fathers than for mothers at common law. I mean, that's not how Lord Viscount Simons expressed it.
Well, can we? I mean, I agree. I agree that in its, as it were, its fiercest expression, the common law treated those born outside wedlock as having essentially no legal status at all. But that's I don't go as far as that. But but on the specific issue that we're concerned with in this case, I do say whatever may be the position as regards that case, as regards the position of a person whose father was not married to the mother, the nationality law very plainly does say that relationship is not sufficient to confer citizenship. And can I just continue with the reference to the articles of the Constitution, my lord? I looked at. I think I got as far as Article 6. Article 8, persons born outside the Bahamas. Here the provision shall become a citizen of the Bahamas at the date of birth if at that date his father is a citizen of the Bahamas, otherwise than by virtue of this article, or Article 3.2 of the Constitution. Now, this is dealing with the position for people born after independence who seek to claim nationality by descent, as opposed to by birth.
It's not just by birth; it's territory and birth, isn't it?
Yes, I mean to say by birth in the territory is what I meant to say. Yes, Your Lordship's right. It's
descent.
Yes, I mean the historical context, of course, I think it's right to say is as of 73, the British position was still a sort of jus soli position. So one was a British national if born in British territory, unless one's parents were enemy aliens or diplomats. So the Bahamas had to devise for the first time their own provision about what happens if you're born on Bahamian territory, and they came up with Article 6. But Article 8 is about descent. But again, it emphasises there the distinction between the sexes of his father as a citizen, and then Article 9, emphasis there, a person born legitimately outside the Bahamas after the 9th of July, whose mother is a citizen of the Bahamas, shall be entitled on making the application, etc., to be registered as a citizen of the Bahamas. So that on its face is pretty clear, actually, and this is dealing with, I think, with Lord Legate's point, actually, that certainly as far as people born outside the Bahamas, in order to claim Bahamian citizenship on the basis of your mother's citizenship, you have to have been born legitimately. So it may be on reflection that I was unwise in conceding what I conceded about, if I did concede it, about birth in the Bahamas. But in any event, it's clear, certainly as regards persons born outside the Bahamas, that legitimacy is what counts. Article 10, then, women who marry Bahamian citizens can become registered citizens of the Bahamas. And then the rest is about deprivation, 11, renunciation, 12, power of Parliament, 13, and Article 14 that we have looked at. So,
well, if you do go as far as saying that no legitimate child born in the Bahamas, no illegitimate child born in the Bahamas will acquire Bahamian citizenship from either of their parents, that's a pretty drastic position, isn't it? If you're adopting that.
Well,
I mean, if your parents are not married, you don't get citizenship, even though they're both Bahamian citizens born in the Bahamas. And
Yes, I do see that.
I thought you agreed with me earlier on it was absurd.
I don't think I quite accepted your lordship's. No, I mean I don't go as far as to say that. But what is striking? I mean, it's striking that. I mean, notwithstanding that your lordship says it's absurd, it is striking that, as far as persons born outside the Bahamas are concerned, the Constitution does indeed have that consequence.
But by absurd, I meant that it was a highly unusual and unexpected result, and one that I didn't think was anticipated by your clients, or
well,
that would lead to, by chance, a whole lot of people losing citizenship.
yeah. Well, my lord, can I just develop the point in relation to the understanding of the term by reference also to legislation which is contemporaneous with the enactment of the Constitution, which is the further point I wanted to make in this context. If we go to, my lord, page 529, that's the Bahamas Nationality Act.
Yes.
Now, this isn't an act concerning the definition of citizenship as acquired at birth, because that's dealt with in the Constitution. But you can see from the short title, it's concerned with acquisition of citizenship or certification, etc., etc. And the relevant provision, which was referred to in the courts below, I think by the minority, is Section 2, the definition section, child.
well, that's obviously a point against you, though, isn't it? Because there's nothing like that in the Constitution.
Well, my lord, I come back to the Lord Wilberforce's point in Fisher that whether or not there is specific provision in legislation, the general understanding has always been that child means legitimate child. Here, what we notice is it includes a legitimate child, but parent, in relation to any such child, shall not include a putative father. So there's an asymmetry there, which is assumed by one assumes that the legislature intended to enact this act consistently with the scheme of the Constitution, and there's the asymmetry that we see. That the parent doesn't include a putative father. In other words, the father of a legitimate child. So that's support for the proposition that the general understanding is the right understanding, not the one which is found favour in the courts below. The other provision is the Status of Children Act, which is at for the relevant provision, it's 542. This is a more recent act.
Can I just before we leave that definition? Yes. Is there anything in the putative father point? I mean, say we had the father, an illegitimate child, but we know that illegitimate child has X as its father. Is that a putative father or an actual father?
I think on the wording of it, I can't recall on my feet whether, and perhaps I ought to know, but I don't, whether putative father is itself a term of art in nationality law. I suspect not, and that the answer is that it means what one would expect. In other words, somebody who is contending that he's the father, irrespective of whether he really is. But I would have thought it
would include somebody who's proved undoubtedly the father, but also intended to be a bit wider and include somebody when you're not sure, but who's believed to be.
Yes. I think that's if I may, my lord, say that's a question that might merit some more thought after the hearing, and I'll endeavour to do that and answer it subsequently, if I may. The Status of Children Act 2002 is the other provision I wanted to go to. That's at 542. This is, as I say, a more recent statute, and therefore is not something I can put forward as being exactly contemporaneous with the enactment of the Constitution, but what it does show is a distinct recognition by the legislature that there were particular provisions about legitimacy which differed from the notion of equal status of children in the Constitution. And you see that from section 3 of the Act, which is at page 544.
Sorry, section again?
Section 3, my lord.
Thank you.
Subject to the provisions of section 6 and 16, and for all the purposes of the law of the Bahamas, and the relationship between every person and his father and mother shall be determined irrespective of whether the father and mother are or have been married to each other, and all other relationships should be determined accordingly. And 2, the rule of construction, whereby in any instrument words of relationship signify only legitimate relationship in the absence of a contrary expression of intention is hereby abolished. But then, importantly, the exception, subsection 3, nothing in this section shall affect or limit in any way any rule of law relating to B, the citizenship of any persons.
Well, it couldn't, could it?
It could.
Citizenship is a constitutional matter, and
yes,
an Act of Parliament can't amend the Constitution.
Of course it can't, my lord, but the fact,
So just recognising
the fact that the legislature thought it necessary to say that is indicative that they thought that what they were doing in this Act was to bring in something that was inconsistent with the way in which the Constitution rules regards parenthood in this context. So, my lord, that's my third proposition. I do respectfully submit that there's nothing in the text of chapter 2 that should cause one to adopt a different interpretation of the notion of parenthood from specifically in relation to who is the father of a child whose parents weren't married, or does a person whose parents weren't married have, for these purposes, a father who's recognised by law? There's nothing in the Constitution, or rather in Chapter 2 of the Constitution, which should lead one to take a different view from the conventional view in nationality instruments of all kinds. Proposition 4, there's no basis for construing Article 6 differently in light of anything else in the Constitution. This really responds to our learned friends' case insofar as it relies upon the human rights provisions of the Constitution, the fundamental rights chapter of the Constitution. Well, the short point about that is that it requires the court effectively to shut its eyes to those parts of the Constitution which are inconsistent with the human rights parts of the Constitution, and neglects to take into account the fact that Article 6 is itself a provision of the Constitution. One can't, in my submission, construe a Constitution by looking at the human rights provisions and saying, well, they, in some sense, trump other provisions of the Constitution. Section 2, Article 2 of the Constitution applies to all of it. It's all supreme law. It's effectively, if one might, without undue impertinence, use this shorthand, it's effectively the Rudal heresy in a different context. In other words, Rudal being the early case about the savings clause in the death penalty cases, which has now been firmly put to bed, and most recently in Chandler. It's about looking at the whole of the Constitution, and the fact that the Constitution contains provisions in it, in Chapter 2 concerning citizenship, which, if they were merely ordinary legislation, one might have a freer hand to read differently or indeed read down because of the fundamental rights provisions, is neither here nor there. If, in fact, as is the case here, they're in Chapter 2, they are constitutional provisions.
Well, that, of course, goes against your argument that you give them a narrow legislative interpretation and not a broad constitutional interpretation as per Lord Wilberforce's approach.
Well, my lord, it was never
the Constitution to look at as a whole.
It's never been my lord. It's never my case that you give the. It's not my case that you give Chapter 2 a narrow legislative interpretation and then take a different approach to Chapter 3. The whole thing needs to be construed as a constitution. I accept that. My point is, and I'll seek to come back, Your Lordship, on some of the questions that were taken in relation to the specific points about the wording of Chapter 2. But my point is that if I'm right that Chapter 2 has the meaning that I say it has, then one can't simply disregard that and say, well, Chapter 3 is more important, and therefore Chapter 3 trumps it. It doesn't work like that, just as it didn't work with the savings provision, to say that because if the savings provision hadn't been in the Constitution, it'd be otherwise, but it's part of the Constitution. But it is, in any event, in my submission, pretty problematic to start holding up citizenship laws, whether in a constitution or otherwise, but especially in a constitution, to human rights scrutiny, because they are all, after all, inherently directly discriminatory on grounds of place of origin, and they're all indirectly discriminatory on grounds of race. But that's the nature of citizenship laws, and it's always been recognized by the courts that a state is entitled to decide, without being accused of acting contrary to human rights, is entitled to decide on the basis of the usual criteria who is or is not a citizen of the state. So it's an area in which one should tread pretty carefully, in my submission, because it's simply not possible to say, well, you just read the whole of the chapter as being subject to all conventional human rights concerns. If one did that, one would effectively undo the whole of the citizenship provisions of any constitution. My fifth proposition, my lord, is that there is, and this is very much made in case this is suggested, but perhaps emerges from some of the questions your lordship have asked. There is no basis for construing Article 6 differently in the light of any change in our understanding of the content of the word parents, and that follows from the fact that parents, as used in nationality provisions, is a term of art. And of course, what I mean by a term of art is it denotes a concept which is not necessarily the same thing. It has a fixed meaning and is not necessarily the same thing as the conventional understanding of the term.
But I thought that parents, you can have biological parents, you can have psychological parents, you can have adoptive parents, and so on. There are
Yes.
major range of parents. But in Article 6, it's parents at the date of birth. And I have difficulty in understanding how you can have an adoptive parent or a psychological parent as at the date of birth, as opposed to a biological parent.
Well, my lord, I think I come back to my proposition that when you're construing a piece of legislation, be it ordinary legislation or a piece of constitutional drafting, where a draftsman or draftswoman uses terms which have an established heritage, when there are notions which are well settled and well established, and when you can tell from the rest of the document that there is no particular appetite to use those terms in a different way, and that's abundantly plain from Chapter 2 in my submission, all the respects we've looked at, then one gives the term its legal meaning rather than its ordinary meaning. So one doesn't start from the proposition that it has an ordinary meaning. One's not looking at an utterance in ordinary speech or in ordinary writing. One's looking at a legal utterance, and in that context, the presumption is that the drafter is using the term as the term of art, as denoting a particular concept. And we know that the particular concept, which is used in nationality legislation as regards parent, is one that employs the concept of legitimacy versus illegitimacy. So
I think we've established that there's all sorts of difficulties with reading that so-called term of art or legal meaning in this particular provision, because it produces the absurdity that we end up with parents of illegitimate children and illegitimate children themselves not being covered at all. So we can't start there, it seems to me. It's a very difficult starting point. There's then also the well-established principle that if you've got different words being used in a statute or a constitution, you would normally think that different meanings are intended by those different words. And we have, on the face of it, different words. We've got father as opposed to parents. So it's not clear to me that you're making, from my point of view, much headway in going back to this idea that we have to start with this presumption, because it just doesn't seem to me on the face of it to make much sense to start there.
Right, well, my lord, I'm very grateful for that indication of your lordship's current thinking, and I will endeavour to formulate matters in such a way that I do make some headway on it. But can we? May I just for the moment invite your lordships just to take to work on the hypothesis that I'm right about that meaning being the starting point, and just deal with this question of whether any change in our understanding of the notion of parents makes a difference. I mean, the short point is, if legislation uses a term, I mentioned this earlier in the context of family, if legislation uses a term, or a constitutional enactment uses a term which is such that it has a certain, it's a concept, but the precise contents of the concept need to be worked out, and other questions may come in, such as social mores at the time it's being worked out, then it's relatively easy to say, well, things have changed, and therefore our understanding has changed. It's not the same if it denotes a concept which has a certain character, and it didn't at the time, it wasn't used as an ordinary word at the time, because, for a start, the fact that it wasn't used as in its ordinary sense at the time means that it's irrelevant to us whether the ordinary sense has changed. And secondly, to do that would be contrary to the obvious intent of the legislator. Well, the passage I want
the common law has changed.
I'm sorry, my lord?
Maybe the common law has changed. You're importing here what you say is a common law meaning, and maybe in a matter of common law, child no longer means legitimate child.
Well, may I
Things have
illustrate
moved on since 1955.
Well, may I, my lord? Well, I'm not sure. I mean,
56. Sorry.
well, 79 was the date of Fisher, so that was this board saying some 6 years after the passage.
All right. Well, since 1979.
But may I just illustrate what I mean by a reference to a very, if I may respectfully say so, helpful passage and clear passage from Lord Hoffman in the Birmingham City Council and Oakley case. That's, if your lordships have it, that's in our appellant supplementary authorities.
Bear with us a moment. Page. It's page 298.
298, yeah, 298. This was the case about the fact that the WC in a council house didn't have a hand basin. And in order to find somewhere to wash your hands, you had to cross the kitchen to go to the bathroom. Did that mean that the premises were in a state prejudicial to health within the meaning of the relevant Act, which, although there referred to as the 1990 Act, had a long historical pedigree? And the passage I wanted to draw the board's attention to in particular is at 312. I think should be highlighted towards the bottom of that page, where the argument was that you had to construe the section in the light of modern conditions. And so did a state prejudicial to health mean a state that would have been so regarded in 1846?
312.
Sorry, 312 between E and F. And Lord Hoffman says just after F, I quite agree that when a statute employs a concept which may change in content with advancing knowledge, technology, or social standards, it should be interpreted as it would currently be understood. And your lordships don't need me to read it all out. Your lordships can see there what Lord Hoffman said if one just goes down to the end of the highlighted passage.
Yes.
So, my Lord, the relevance of that to our submission is simply that if I am right, and I accept I may have more work to do on this, but if I am right to say that the Constitution, as enacted in 1973, employed the concept in the way in which I say it did, then changes in the understanding generally about what's meant by parents can't make a difference to matters.
Sorry for bringing you to your case, electronic page 495, paragraph 10. You challenge the concept that the ordinary grammatical meaning is biological parents. And you give an example of a married couple who brought up a child, but unbeknownst to him, he was in fact illegitimate. And I mean, that's a classic example of a psychological parent. But do you accept the proposition that the ordinary grammatical meaning, that a psychological parent can only arise over a period of time? And if you're thinking about Article 6 and parents as at the date of birth, that can only be biological parents.
I don't think I do accept that, my Lord, but I think I would.
Well, it's quite. I would have thought it's quite consistent with your case to say that you say it refers to a subset of biological parents. I mean, that's what you're saying, isn't it? You don't have to depart with biological parents altogether and say that other sorts of parent are included, do you?
No, I mean the reason I said what I said in paragraph 10 of the case is to make the point that it's actually not very helpful to say, well, this must be the ordinary meaning of parents that's in play here, and so we need to.
But even if your case about legal meaning starts with some other meaning before you exclude the people who are illegitimate. I mean.
Yes, I think
your argument is only one about whether the parents are married or not, but they've still got to be parents in some sense to even get in the door.
Yes, I think I accept that, my Lord. Yes.
And indeed, you rely upon biological parents because you say prima facie, it's a mother married to a husband, unless you establish, of course, that somebody else was the father of the child, and. So you rely upon biological parents as well.
Well, yes, but I think I'm accepting Lord Legate's point that it's a subset of biological parents. Yes, but the point I was making by reference to that passage is I hope a clear one, which is that if you're once you accept that the task is not simply to look at the term in its inverted commas ordinary meaning, but rather that what the drafter has done is to use a term of art, then that deprives a court subsequently of the luxury of saying, well, things have changed in terms of. And I think, in fairness, it's not a centre point of our learned friend's case to say that the meaning of parents has changed. My Lord, the sixth proposition is that there is no basis for construing Article 6 differently from the way I say it ought to be construed in the light of international obligations of the Bahamas. Still less on the basis that this would be consistent with the momentum of international human rights law. And this responds to paragraphs 13 and following of our learned friend's case, where they put it in those terms. That's page 511. And as I understand it, our learned friends make a general point about the momentum of international human rights law and decided cases around the world, and they also refer specifically to the American Convention on Human Rights, which has an express provision in it that the law shall recognise equal rights for children born out of wedlock and those born in wedlock. That's page 514, para 18 of their case. Well, I can deal with those, if I may, in reverse order. So far as the American Convention is concerned, the short point is that the Bahamas is not a signatory to the American Convention on Human Rights. It's not a party. I think that's common ground. Our learned friends say, well, there's a report of the Inter-American Commission that says that, nevertheless, by signing up to the Organization of American States, the Bahamas has become obliged in international law to comply with the convention, but in my submission, that's not what the case says. And if it did say that, it would be wrong, because the straightforward point is that to the extent as a matter of international law that states are obliged, the extent as a matter of international law to which states are obliged to comply with obligations is governed by international law, and all the ordinary principles apply. If it's a treaty obligation, you have to sign up to the treaty, unless it's one of those treaties that codifies customary international law. So in my submission, that doesn't get anywhere. And in fact, the case to which our learned friends refer, which is the case of Edwards, is a case about the American Declaration of Rights. And my lord, we see that if you go in the electronic record to page 515. I think that's the right reference. We can see, I think there, the beginning of the case.
Tab 21.
Okay, sorry, it's 11, I'm sorry, 11, that's their reference to 1143. 1143.
Thank you. Yes.
And in fact, you can see from paragraph 1 that the complaint there is a violation not of the American Convention on Human Rights, but of the American Declaration of the Rights and Duties of Man. And we put that in our supplementary authorities at page 396. Where you can see that if you track down to page 400, you can see what Article 19 says about nationality.
396.
Article 19.
Article 19, page 400, yeah. And your lordships will see it's a pretty anodyne provision. Every person has the right to the nationality to which he is entitled by law, and to change it if he so wishes. So that won't help the court, help the board at all with the answer to the question in the present case, in my submission. As regards the general point about the momentum of international human rights law, I don't, of course, invite the board to reverse its previous jurisprudence of saying that it's a canon of construction that you should adopt a construction that puts the state in compliance with its international obligations if you can. But that doesn't help. That reasoning doesn't help when the answer is, when the submission being made is that you should just look at international human rights law generally, and indeed look at a selective set of other countries and what they do, which effectively is what has happened, what is being submitted in the present case. And I highlight also the Supreme Court's decision in RC against the Secretary of State for Work and Pensions, which is, of course, a recent decision that your lordship will be familiar with, having sat in, and two of your lordships, I think, having sat in, and
Is that in supplementary?
it's 320, and it's 320 in our supplementary authorities. And that, of course, was the case where I think it was Lord Wilson had talked about the conclusion harmonising with international obligations. That case, they definitely were international obligations because it was a treaty that the UK had in fact signed up to, as opposed to the present case. But from paragraph 75 onwards, in Lord Reed's judgment, we see the explanation there about I mean, it's all very familiar stuff, of course, about the dualistic nature of international law and its reception in the United Kingdom. So all I go to that to underscore is that one needs to be pretty careful about saying, well, this conclusion that I'm being pressed to adopt would be one that would be consistent with international obligations. For a start, you've got to find out there really is an international obligation, and secondly, query exactly to what extent you can import international law into domestic law. Answer, only really when it's been imported. Subject only to, as I say, I don't invite the board to make this the case to back away from the general proposition that where there's ambiguity, you can construe it so as to keep the state in compliance with its international obligations. But they've got to be there. My final submission is, and I'm a little bit ahead of schedule, so I might, if I may, seek to add this time on to my reply, is this. There are, my seventh proposition, there are good reasons why any change in the understanding of either of his parents needs to be made democratically and not by courts through judicial decision. And it's of course right that there has been a general understanding that Article 6 means what the minority in the Court of Appeal said it meant for some time. I think that it's expressly adverted to in the Court of Appeal in the minority judgments that this is a significant change in understanding. But the reason I say that any change needs to be made democratically and not by the courts is this, because if one is to drop an established understanding, if I'm right about what the established understanding is, if one is to drop an established understanding, one needs to work out precisely what one puts in its place. And it's not necessarily obvious what one puts in place of it. If one says, well, we don't wish to, and therefore aren't going to construe this constitution as adopting this now archaic notion of legitimate versus illegitimate child, specifically in relation to in this case, in relation to the father. One has to decide what one puts in its place. Is the alternative, well, there has to be at least a relationship akin to marriage, a partnership of some sort? Or is it enough to have mere biology, mere genetics? And if it's the latter, what about the mother? What about those cases which can now arise where the child is not genetic offspring of the mother who
well, in order to be a parent, you don't have to have some particular sort of relationship with the other parent.
Well, Your Lordship says that, but that's not initially how it was viewed in the United Kingdom when the matter was looked at when he was changed. Can I just take, Your Lordship? This is also in our supplementary authorities. First of all, the Nationality, Immigration and Asylum Act, which is the first tab. It's page 2 in our supplementary authorities. I'm sorry, by the way, that the whole thing got copied into the PDF, so it's much longer than it needs to be. The relevant provision is at page 8. It's section 9, substituting a new section 50, subsection 9 of the British Nationality Act 1981, in order to do away with the distinction between legitimate and illegitimate children. And the first point of note is new subsection 9. For the purposes of this act, a child's mother is the woman who gives birth to the child. So Parliament felt it necessary to spell that out. I suppose, lest it be said that actually a genetic mother would count, even if she hadn't actually given birth to the child, which itself is actually a significant policy choice if one thinks about it, because if the person who gave birth to the child is a surrogate, then the mother who has decided to have a child by that means might herself have something to say about the proposition that it's the nationality of the surrogate that matters. But that's what was decided by Parliament. And then 9A, as far as father, the husband at the time of the child's birth, of the one who gives birth to the child, or a person who's treated as the father under Section 28 of the Human Embryology and Human Fertilisation Embryology Act, or where neither A nor B applies, any person who satisfies prescribed requirements as to proof of paternity. And that then takes you to 9B and the regulation making power, which I'll come to in a second. And then 9C simply makes the point that you construe parent, child, and descendant in accordance with those subsections. So when the minister first had to make regulations under the power there described, the regulations were made not in the form, in fact, which is in our additional bundle whose PDF you're looking at the moment, but in a different one, which I sent across yesterday. I've read it and came across this yesterday, so I hope it's reached your lordships. It's a PDF called UK Paternity Regs V1 and Referendum Bill.
Yes.
I apologise for the fact that your lordships are yet again having to flick between different tabs to get everything, but that's the way it unfortunately turned out here. So this was the version in force from the 1st of July 2006 to the 9th of September 2015. The following requirements are prescribed as to proof of paternity for the purposes of Section 59AC of the Act. The person must be named as the father of the child in a birth certificate issued within 1 year of the date of the child's birth, or the person must satisfy the Secretary of State that he is the father of the child. So there's a clear policy decision being made there that it would be sufficient to be named as the father in the birth certificate. Of course, it could have
Well,
said...
that's just creating a presumption, but the basic point here, it seems to be treating whoever is the biological father as the father.
Well, it's biological father plus.
You must either prove it or you don't have to prove it if it's in the birth certificate.
Yes, but by saying that these are the requirements as to proof of paternity, it's actually moving away from strict biological parenthood, because if the person is named as the father of the child in a birth certificate, then that's it. That's proof of paternity, irrespective of whether biological paternity is proved. I take the board to this merely to illustrate the point that actually there are policy choices to be made about what you replace the old way of looking at it with, if that's what you decide to do. Anyway, that was the position until September the 9th, 2015. And then if we go back, sorry to jump around, to the additional bundle of authorities, we see how it now stands. This is page 294, tab 2. And it's been simplified.
We're
Regulation
back in the
2.
main bundle.
Not the main bundle, back in our supplementary authorities.
Supplementary bundle. Yes, thank you.
Just over on to page 295, Regulation 2. The prescribed requirement as to proof of paternity is that the person must satisfy the Secretary of State that he is the natural father of the child.
Right.
So that does emphasize pure biology. And as I say, I've made the point, and this doesn't need endless repetition, but I make the point. That illustrates again that there are policy choices to be made, and one can't simply say, well, it's obviously a matter of biology, and that's that. The only other document I wanted to take the board to in this context is, I'm afraid, going back to my most recent offering that your lordships were looking at a few seconds ago, and that's just to look for information really at the Bahamas Constitution Amendment No. 3 bill. Because one of the striking things about this appeal is that the courts in the Bahamas, if they're upheld by your lordships, have changed the understanding of the meaning of Chapter 2 in this context in a way.
Just to be clear, what are you relying on for saying that this is that is changing the understanding? Is that the statutes that you've taken us to that you rely on for that?
It's the it's
Where does this understanding, where do you get it from?
I get
There
it-
isn't
I
some
get it-
long history of case law.
I get it from Fisher, and I also get it from the decision in the Bahamas, which preceded this issue, which is the case. I think it's called K. Let me just find it.
Right.
If you've asked about it. It's page 1351 in the main, back in the main bundle.
But that decided the question as a matter of just statutory construction and or constitutional
Yes.
interpretation, just as the later case, as it wasn't saying, oh, well, this is how it's always been understood, and therefore that's how I interpret it.
No, I
just don't
think I
see
agree
where
with
you get the starting point that this is disturbing some accepted understanding. It seems to be just a question of what's the right interpretation. And there are two decisions that have taken different views at first instance, and that's all we've got.
Well,
Precedent.
yes, but if I'm right about what I say about Fisher and the adoption of the terms of art, etc., then that I also derive from there my point about the settled interpretation. But I also derive that.
Well, if you're
as I
right
said,
on that, then you're right. But
yes. I can pray in aid, actually, in support of that. Also, the Bahamas Constitution Amendment Number 3 bill.
Where do we find that?
That's in my most recent thing that came across yesterday, which your lordships just were looking at for the UK regulations. It's page 3 of that.
Yes.
So this is.
How does that relate to the other references to father in the Constitution?
Well,
apart from Article 6, how does that impact on the other?
If we look at the way this works is that, first of all, I should say this. Although this is a bill, the only reason it's not an act is because it was a bill that, to take effect, needed to be approved by referendum, and it wasn't. Yeah. This was the 2016 referendum where this was rejected, but it was otherwise it passed all the relevant stages in Parliament. So this demonstrates Parliament's understanding of the existing law and what was necessary to change it. You get, if we go to the text of the bill. Paragraph 2 of the bill, amendment to Article 14 of the Constitution, so it puts a new paragraph 14 in, or it would have done if it had been approved. Father in relation to a child born out of wedlock means a person who is proved in a manner recognised in law to be the father of that child. So that was the policy that was being adopted then in relation to the definition of father in Article 14.
So that would definitely have an effect on Article 8 then of the Constitution.
Which refers to people born outside the Bahamas, yes. Yeah. And then, if you look at the way in which Parliament expresses the question at 3, do you approve of this bill, which seeks to alter Article 14 to enable the Bahamian father of a child born outside of marriage to pass his citizenship to that child, just as an unmarried Bahamian woman can presently do, but subject to proof of paternity? And then there's a statement of objects and reasons. Seeks to amend Article 14 to remove the specification that a reference in the citizenship provision, etc. The removal of such a reference would enable a Bahamian male who is proven to be the natural father of that person to pass on his citizenship to that person, just as the natural Bahamian mother presently does under the Constitution.
That may reflect the understanding of
I say that.
Surely it's for us to decide.
Yeah, of course. That's the privilege of the judicial office. What legislation of any sort means is ultimately a matter for the court, not for Parliament. But it is. I go to this for 2 reasons. One, it's a supplement to my earlier references to the Bahamian Nationality Act and the Status of Children Act, all this and those two collectively indicate that there was an understanding as to the meaning of the terms which I say is consistent with our case. And we've given the references in our...
Was that understanding what? I just didn't pick that up.
Well, the submission, my lord, is that you can deduce what what the drafter of a particular legal instrument meant by looking at other legal instruments, not only before but unless there's been some dramatic change afterwards, so as to construe them. And so the fact that Parliament thought it was necessary in order to, without making any particular reference to Article 8 and saying, oh no, this only applies to people who are born outside the Bahamas, the fact that Parliament thought it necessary to enact this or to seek approval for a change in the Constitution to enable a child born outside marriage, unqualified, not whether in or outside the Bahamas, but the child born outside marriage to pass his citizenship, a father rather of a child born outside marriage to pass his citizenship. The fact that Parliament thought it necessary to do that indicates that Parliament's understanding of the Constitution is in accord with our understanding. That's the point.
But at the time, there was a legal decision saying that. Re-K.
That is...
So that was the interpretation, as I understand it.
I think that is right, but I'm just checking whether your lordship's right about the chronology. I expect you are, otherwise you
I think it was 2007, the weekend.
Yeah, no, that's true, I'll accept that. Yeah, I accept that. But that's the first reason I draw attention to this provision, and the other reason is to go back to my 7th proposition about the importance of taking into account the fact that you can't just change without deciding what you're changing to, and the proposed amendment shows the way in which it was determined, it would have been determined by amendment of the Constitution that the change should be given effect. A person who is proved in a manner recognised in law to be the father of that child.
Does your submission go as high as to say that if we were to interpret these provisions in the Constitution against you, that is, that we would read it as natural parent, including in relation to an illegitimate child, that subsequent legislation would be inconsistent? That there have been developments subsequently that would render that interpretation inconsistent with those subsequent developments? Or are you just saying, the slightly lower proposition perhaps, that there are difficult policy choices here?
And may I just take a moment just to remind myself of the text of one document that is relevant to the answer to that question. Well, I don't think I can say that finding in our learned friend's favour in this case would positively impede the proper operation of some other piece of legislation. I mean, I'm answering the question on the hoof, so it may be that somebody will point out that I'm wrong about that, and there is something which would be impacted by it. In which case, I'll let your lordships know through the usual channels, if I may. But I do submit that it would be, so to decide, would be inconsistent with the existing corpus of not only the Constitution on my proposed analysis, but also other pieces of legislation, in particular the Bahamas Nationality Act, which makes provision about child, including illegitimate child, which in the context of nationality is completely unnecessary if our own friends are right. And likewise the referendum bill. My Lord, I think for the present, unless there are specific questions that you'd like me to deal with at this stage, those will be my submissions.
Thank you very much, Mr. Rowe. I can see you looking at the clock. You brought it in way ahead of time.
Well, as I say, depending on any thoughts I may have over the short adjournment, I might seek to claw some of that back in my reply, but I'm in your Lordship's hands about that, of course, I accept.
Yes. Mr. Fitzgerald.
Yes. Well, my Lord, we've set out our response in the case, but can I just deal with one preliminary point, which is about the question of an understanding in the Bahamas of the correct interpretation of Article 6 and Article 14. There is some evidence before the board in relation to that, and you have that at tab 38. Sorry, that's page 1605. This is the report of the Commission, which included a High Court judge, a former Attorney General, a member of the Attorney General's Department, and a professor of law. And they deal with it. The Commission report starts at 1585 in the bundle, and the key passage is at pages 1605 to 1606. And one sees there that this is 2013, this comes out. The Commission is of the view that this provision is not discriminatory. It adopts a hybrid position between acquisition of citizenship based on birth in territory and descent, and the combination of each grant's entitlement at birth. However, it seems to have been susceptible to an interpretation that is discriminatory in its effect. This results from the Commission considers to be the erroneous interpretation of the words parents in this provision to include an unmarried Bahamian mother, but not an unmarried Bahamian father. In several cases, and they refer to K in the footnote, the courts have construed the reference to parents in Article 7 to be caught by the definition of father in Article 14.1, and therefore the potential benefit of this article to a child born out of wedlock in the Bahamas to a Bahamian male is removed. However, it seems, and they footnote the cases, however, it seems fairly clear that the intention of Article 6 is to grant automatic citizenship to a child born in the Bahamas, an objective condition where at least one parent is Bahamian, another condition that is capable of being objectively determined. The only difference in the case of a male parent is that the common law, eminently rooted in common sense, has always required proof of paternity before those other rights can attach, as it is not really readily clear who the father is. Automatic transmission of citizenship through patrilineal descent could produce absurd results, but an unmarried Bahamian man whose paternity of a child has been legally established or acknowledged should be fully able to transmit his citizenship to his offspring. And then it deals with the question of those born overseas in 14.16. But my Lord, and this is an error in the judgment of the President, he says it's been a settled understanding for 40 years. There is a distinguished commission, which is, you'll see the composition of it at 1593. Carl Bethel was the former Attorney General, Madam Justice Reuben Nottage, the others were attorneys, Professor of Law Michael Stevenson, Attorney General's Office Lauren Klein, now a judge. They were saying no, and anticipating the judgment that your lordships have seen. So, my lord, it isn't right that this upsets a settled understanding. And we respectfully submit that the judgment of Mr. Justice Winder, now Chief Justice Winder, was correct. We've summarised the effect of it in our case at 502. His finding was that either of the parents in Article 6 means either of his biological parents, and just pausing there, we respectfully adopt the points that have been put, particularly my Lord Stevens's point that it's got to be something you can determine at birth. And then Mr. Justice Winder reached his conclusion in a matter of ordinary construction, applying well-established principles of interpretation, and we respectfully submit that the phrase either of his parents is not to be construed as importing any requirement of legitimacy in the manner contended for by the appellant. Article 6 confers automatic or birthright citizenship on every person born in the Bahamas after the 9th of July, if at that date either of his parents is a Bahamian citizen. And then we make the point that my Lord Borough has made, that there has to be some significance to this shift in language. The starting point is that Article 6 does not use the words father or mother, and father is the word used in Article 14. This stands in plain contrast to 3(2) and 8, and that those concern birthright citizenship for those born outside. So you've got the word father or mother is used in relation to those born outside the Bahamas, the word either of his parents in relation to those born in Bahamas, and then the question, what does Article 14 bite on? It bites on the word father. It provides an interpretation of the word father, and this is at page 563 of the electronic bundle. Any reference in this chapter to the father of a person shall, in relation to any person born out of wedlock other than a person legitimated, be construed as a reference to the mother of that person. So, that obviously would apply because the word father, as your lordships have observed, occurs in 3(2) in relation to a child born outside the former colony of the Bahamas, and it occurs also in Article 8. A person born outside the Bahamas shall become a citizen of the Bahamas at the date of his birth, if at that date his father. So if you ask yourself, what does Article 14 bite on? It bites on the word father in Article 3(2) and Article 8, and continues to do so, but not on the words parents, which are quite separate concept, in Article 6. And my Lord, that's essentially the judgment of Mr. Justice Winder. We've summarised the key points in his judgment at 503. He says that, so 503 at 3A, contrary to the assertion of Chief Justice Hall in K, the use of the words either of his parents in Article 6 cannot be explained by simple economical use of language by the draftsman of the Constitution. That's to say, he makes the point that it was just as economical. I mean, it takes as much space up.
You count the number of words.
Yes, yes, oh my Lord. Secondly, the presumption that different words in a legislative enactment carry different meanings.
So I think it's not against you now, not that it's an economical use of language, but that it's
Shorthand.
shorter. But not that it's shorter in terms of the number of words, just a convenient way
Yes.
of referring to it.
Yes.
That in the particular context of the structure of the sentence, it's easier to refer to parents and
Yes.
father and mother.
Well, my Lord, what we say is you can see clearly that the word, I mean, it's really, what does Article 14 mean? It says, it interprets wherever the word father is used, what it means. And then you say, well, where is the word father, this specific word father used? And it is in Article 3(2) and Article 8. And my Lord, if this is a limiting provision, that is to say, limiting the scope of a right otherwise conferred, there is very clear authority that in interpreting a limiting provision of that sort, it should be strictly construed so as not to restrict rights. And that's in the case of Hughes in the Privy Council in Lord Rogers' judgment. In the case of a case called Petrus, they're all in our supplemental authorities. But, my Lord, I'm just trying to summarise what Chief Justice Winder says, and then it's at B, the presumption that different words and legislation carry different meanings applies and is not rebutted by the context. That's at paragraph 18 of his judgment. And that's, so paragraph 18 of his judgment at 72. And then your lordships will see, ultimately, however, it's not a question of counting words, but of meaning. Regrettably, Chief Justice Hall does not proffer a basis for his view that the use of the parents was merely economical use of language. The interpretation advanced by Chief Justice Hall and the respondent does not account for the deliberate shift in language and ignores the presumption that different words in a legislative enactment carry different meanings. And then he sets out those points which have been put to my learned friend already by my lord.
I'm not sure I can accept the economical use of language point, because the point you also make is that it wouldn't have been any good to put father or mother in there, because then that leads to the substitution of mother or mother,
Yeah,
which is ridiculous. So if you did want to achieve what the appellant says, you would in fact, the drafter would in fact have had to have a rather more convoluted
Yes.
explanation, wouldn't they?
Yeah,
Than simply to put father or mother,
Yes, my lord, yes, and well,
or either father or mother. So it would have taken more than 4 words, I think.
yes.
Because you want to count the mother anyway, and the father only if
Yes.
if it's a legitimate child. That's the gist of it, isn't it?
My lord,
Well, at least on one view of the appellant's case.
well, word counting aside, there are two clear conceptual uses: that of parents in Article 6, and then that of father, which is in 3.2 and 8, which is then interpreted restrictively Article 14. And really, one can't see how Article 14 can be made to bite on a word other than father. And it makes perfect sense, because then you apply Article 14 to those provisions of the Constitution dealing with the rights of those born outside the Bahamas, which have come nearer to Article 14, because Article 8 is the last, as it were, thing mentioned, and that makes sense of and limits the effect of that exclusionary clause, if I can call it, or limiting clause. And so if we look at the summary that we've put in paragraph 8, the careful and detailed structure, this is at 3b, of Chapter 2 of the Constitution suggests a clear intention to treat differently those born outside of marriage, that's in 3.2 and 8, and those born within the Bahamas. And in the former case, the effect of the application of Article 14 would be disentitlement to the fundamental and automatic right to citizenship that had hitherto applied. Yes, it is quite important, as my learned friend said. Up until 1973, you just had to be born in the Bahamas to have an automatic right to citizenship. That's from the British Nationality Act of 1948. And that's referred to in the judgment of Justice of Appeal Evans. Sorry, can I just give the reference to Evans? At page 214. So you had an automatic right from birth. Now this, Article 6, limits it to birth and heredity. Either of your parents must be born in the Bahamas. Be a citizen. Be a citizen of the Bahamas. Either of your parents must be a citizen of the Bahamas, but no need then to restrict it even further and say legitimate relationships only count. And so we submit.
So before this, illegitimate children born in the Bahamas were citizens.
Absolutely, yes. So this is.
And so if you construed it as ruling out if you construed parents as meaning legitimate parents, that would actually narrow the class by disenfranchising people who previously would have
absolutely, my lord.
By virtue of birth.
Yes, and Justice of Appeal Evans laments that fact. He says we've restricted the rights, but that's a reason not to adopt an interpretation which even further restricts the rights. So, my lord, that's 3b. I think I'm just summarising. The only other use of the word parents, of course, is in the proviso to Article 5.6, which concerns has nothing to do with the legitimacy of the person concerned. And then, my lord, there's a point that he makes about the anomalous or absurd results which would flow from the contrary interpretation. The child of an unmarried Bahamian mother born in the Bahamas would have an entitlement to automatic citizenship, but the child of an unmarried father, also born in the Bahamas, whose paternity has been legally established, would have no such entitlement. As Chief Justice Winder observed, he passes his blood and DNA, but not his citizenship. Secondly, the clear intention expressed by the words of Article 6, namely to confer automatic citizenship on every person born in the Bahamas, where at least one parent is Bahamian, would be frustrated. And then finally, the child of a Bahamian father, where the mother is a non-citizen, would be placed on the same footing as a child whose parents were both non-citizens. Both would have to wait until they had attained the age of 18 and then make an application for citizenship pursuant to Article 7. It's a discretionary power to register in Article 7. And then the absurdity point that my lords have all commented on, if the reference to parents were instead to be read as father or mother, in effect, the effect of the application of Article 14 would be, instead of reading parents as mother or mother, which, as Chief Justice Winder observes, is an absurd result. And so we respectfully submit that he was right to say it referred to biological parents, right to say that Article 14 did not bite on Article 6. And that was all there was in the Kay case. It was just, you read it as mother or father, Article 14 bites, that's it. There wasn't anything more profound in the earlier decision. And it had already been exposed as fallacious or reasonably criticised as fallacious in the Commission's report in 2013. And then, my lords, if we go on in that, we say that he didn't start from an improper premise. The premise that it was biological parents was a proper one, and he looked at the context and whether Article 14 did bite on it. Now, my lords, at this stage, I could deal with the point of subsequent legislation, if that would assist the court, but can I?
We're in your hands.
Okay, fine. Well, okay.
If you want to deal with Brandy Syndicate or whatever, if you want to deal at some point with Brandy Syndicate, we'd be assisted.
Yeah, okay, fine. Okay, my lord. Well, you see we've summarised our position in paragraph 5, that they rely on two bits of later legislation. That's the Bahamas Nationality Act that my learned friend's taken you to, and the Status of Children Act, 2002. Now, my lord, can I just deal with those? So, well, first point is that it's not permissible to have resort to subsequent legislation where there's no ambiguity, and we say there is none. In the Cape Brandy case, at page 591, you will see that the principle of subsequent legislation being looked at is referred to in the judgment of Lord Sterndale at page 590 of the...
What's the electronic?
Page 590 of the electronic bundle.
Thank you.
So this is, I've taken you straight plunged you into the case Brandy, but the key bit is about 3/4 of the way down. I think it is clearly established in Attorney General and Clarkson that subsequent legislation on the same subject may be looked to in order to see what is the proper construction to be put on an earlier act, where that earlier act is ambiguous. I quite agree that subsequent legislation, if it proceeded upon an erroneous construction of previous legislation, cannot alter that previous, so that's quite important. But if there be an ambiguity in the earlier, then the subsequent legislation may fix the proper interpretation, which is to be put upon the earlier. So that's Cape Brandy. So it is looking at the question of first you've got to have ambiguity, and then you can look at it. But the second point in relation to that is the case of DSG Retail, which is you have in 1296 to 1297, and that applies the Cape Brandy principle. In other words, at paragraph 57 of DSG Retail, page 1296 of the electronic bundle at the bottom, if your lordships have that. In the course of argument, a lengthy debate took place as to whether or not it was appropriate to use later primary and delegated legislation to interpret earlier legislation. Many authorities were cited, most of which were referred to in customarily erudite passages from Benyon. Under the respective headings, inferences from later acts and law should be coherent and self-consistent. My lords, could I underline that? Because that's really the underlying rationale of this rule, that you want coherency of the kind of legislative body as a whole. The principle stated under Section 24 to 19 is that where the legal meaning of enactment is doubtful, subsequent legislation on the same subject may be relied on as persuasive authority as to its meaning. And then it refers to Kate Brandy Syndicate and the Inland Revenue. And then it says, paragraph 58, the problem here is that the earlier legislation is not, I think, ambiguous. It's only if you reason that. Firstly, we say it's not ambiguous, it's clear, and Chief Justice Winder got it right. Secondly, we respectfully submit that in any event, it would be a strange thing if you reasoned from ordinary legislation of Parliament to a reinterpretation of the Constitution.
The simple point is surely it's not dealing with citizenship in the other acts. It can't, because it's a constitutional matter. So what do you use for another purpose, like adoption or something, or immigration control, is not the same as citizenship. Doesn't tell you anything about what's the correct interpretation.
Sorry. Yeah, my lord, that is the third point. It's not the same. So if you look at the British Nationality Act, it's an act to provide for the, quote, acquisition, certification, renunciation and deprivation of citizenship. It doesn't deal with the issue of birthright entitlement under the Constitution. It just doesn't deal with that. Section 6 provides for the registry of the Nationality Act, which you've got at 529 following, provides for the registration of a minor child of a citizen of the Bahamas. But such a child could be born outside of the Bahamas so as to benefit from the provisions, so as not to benefit from the provisions of Article 6 of the Constitution. So the interpretation of Article 6 adopted by the courts below does not render Section 6 of the 1973 Act redundant, and it's not inconsistent with the existence of Section 6. And then my final point, my lords, is if there were a conflict between subsequent legislation and the Constitution, it would be wrong to limit the scope of a constitutional provision to accommodate consistency with the supposed requirements of an ordinary Act of Parliament. Procedurally, Section 6 of the Nationality Act allows for a parent who is a citizen of the Bahamas to apply for the registration of their child. The child who can be registered can include an illegitimate child, but the parent who applies cannot be the putative father. I would say putative father is someone claiming to be the father but not proven to be, but it doesn't alter our interpretation. So the mother who is a citizen can apply, equally the father is confirmed can apply. So we say this is one, there's no ambiguity, two, they're not on the same subject, and three, there's no inconsistency. If we look at the state...
Indeed, in the Nationality Act, they have a provision which says that father does not include the putative father of an illegitimate child, doesn't it?
Yes.
And there's no such provision in the Constitution.
No, my lord. So the Constitution...
I mean, if they wanted one, they could have put one in, presumably.
Yes. Well, you mean by amending the Constitution?
No, by drafting it that way in the first place, in the interpretation section, when they chose to put in a meaning for father, and they didn't include as part of that that the term parent will not include a father of an illegitimate child, like they have in the Nationality Act.
Yes, my lord. I respectfully agree. And can I just deal then briefly with the Status of Children Act? That's tab 3 at pages 542 following. And the so it's the Status of Children Act, and if we look at section 3, my learned friend took you to it. 3b, nothing in the section shall affect or limit in any way any rule of law relating to the citizenship of any person. So it doesn't answer the question how you interpret Article 14. It remains untouched and unaffected, but that begs the question, what is the scope of Article 14? And it's our case that its effect is limited to qualifying the term father in Articles 3, 2 and 8. And again, so you can have a sensible and coherent interpretation of the Constitution consistent with the overall legislation. And more fundamentally, again, I make the same point, the provision of a subsequent statute, I mean, long after, cannot and does not purport to interpret the Constitution and cannot, as a matter of law, be relied on to reinterpret the Constitution. And then we make the point that in any event, if we're dealing with, well, does subsequent legislation clarify a settled understanding of the Constitution? We've got the Constitutional Commission with pretty distinguished members saying that they reject that interpretation in 2013. So the most that the Status of Children Act provisions does is to indicate that Parliament was leaving untouched the interpretation of the ambit of Article 14 to the extent that Article 14 was fought by some to limit the rights under Article 6. But of course, that begs the whole question, do they? And I've made the point that as to the previous understanding of the law, the President, Justice Barnett, suggested that the analysis of Hall CJ had been the manner in which Article 6 has been interpreted by those administering the citizenship laws of the Bahamas from 1973 onwards. We don't accept that in the light of the Commission's finding. And I think the board has, so those really are the pillars that are relied on in terms of interpretation. We say the ordinary meaning and the meaning in context is that parents means biological parents. That's the first point. Secondly, that Article 14 does not, for the reasons that Chief Justice Winder gave, a bite on Article 6. Thirdly, it would result in anomalies and absurdities if you adopted the interpretation in the K case and of the minority. And fourthly, that there is nothing in subsequent legislation to compel a different approach to that taken by Chief Justice Winder. My Lords, can I, before going on to any further points, I've submitted therefore that on the basis of our case, Chief Justice Winder was correct, coherent, and produced a sensible interpretation of the interplay of the constitutional provisions. The Court of Appeal has been criticised because at some passages they seem to be applying a test of whether the majority seem to be applying the test of whether the judgment was challengeable on kind of judicial review principles. To the extent that that impression was created, we accept that it would be wrong and that the President, Justice of Appeal Barnett, was correct to say the question is a straightforward question of what is the right interpretation of Article 6. But
they do say that in terms.
Yes, absolutely. Can I just give you the reference?
It's a bit troubling if that's how they're approaching the job every day of the week.
Yes.
That they start off with the decision on a point of law of the judge as correct unless it's shown to be plainly wrong.
Well, my Lord, can I just redeem and rehabilitate the Court of Appeal in these ways? If your Lordships look at paragraph 204 of Justice of Appeal Crane Scott, there's no doubt that she is saying for herself.
Sorry, we're going to page
204 of
yes.
the record of pleadings. So
yes.
204. She says there quite clearly. 100. I'm so sorry. 104. It's 104. It's paragraph 104. I'm so sorry. Page 169 to 170. Yes. I'm going too fast. Sorry. It's paragraph 104, and she says, "I am satisfied that the proper interpretation which the framers intended to be given to Article 6 of the Bahamas Constitution is that every person born in the Bahamas after the 9th shall become a citizen of the Bahamas if at that time either of his biological parents is a citizen of the Bahamas, irrespective of the marital status. So that's a conclusive finding by her that in fact the interpretation adopted by Chief Justice Windup was correct. And there's no doubt about it. And there are other passages early where if you look at her reasoning at 87 to 88, page 167, she says, I find no fault in his reasoning. And she says at 88, in the result, I cannot say judge's approach of his conclusion were erroneous or wrong in any respect. Effectively, she's saying it's right. Justice of Appeal Isaacs gives his key finding at paragraph 132, and this is his own, as it were, interpretation. Like the judge, that's to say the judge first instance, and Justice of Appeal Crane Scott, I find that the draftsman's shift in language is illustrative as intent. The words parents and father were to import a different meaning to each. The clear words of Article 6, either of his parents as a citizen of the Bahamas, leads inexorably to the conclusion that the intent is to avoid any apparent discriminatory feature in the Constitution. That is to say, both mother and father of the child are placed on an equal footing, with no regard as to any artificial differentiation of legitimate or... Well, that's a finding that there is only one interpretation, and it is the interpretation.
It doesn't really matter, this, though, does it? Because we've got to make our own minds up, and you're not suggesting that we defer to the finding of the Court of Appeal, are you?
No, my lord, you're quite right.
The question is, what's the right answer?
Of course, my lord. I'm just, because that criticism has been made, I think it's right that I should. Yeah. I'll just draw you the attention. There's.
I mean, do you say they add anything, in fact, to the reasoning? Well, I couldn't, amongst all this, goes on for a long time, but they really seem to be saying that he was right, and that's about it, really, isn't it?
Yes. There's actually, funny enough, in Justice of Appeal Jones, he provides, isn't he, with an explanation, yet he provides. Yes, sorry, it's Evans, isn't it? Yes. Paragraph 83, 183. No, my lord, we have founded our case and our argument that Chief Justice Windup was correct. His reasoning should be followed. There are some additional points made by the Court of Appeal, and indeed, even in the dissent of Justice of Appeal Evans. Yes, that's absolutely yes. Yes, that's absolutely yes. 16, yes. So yes, he does. Yes, there is one thing in the approach of Isaacs, Justice of Appeal Isaacs, where he explains, I think, in terms that my lords have already drawn attention to, he gives a reason for confining the ambit of the application of Article 14 to those born outside the Bahamas, and that's at paragraphs 131 to 132 of his judgment. And I think the point is that it's making. Yes, I just draw attention. In the circumstances, the necessity of determining the nationality of a child born, that says 178, born out of wedlock to a Bahamian woman was of some importance because of the common law principle of filius nullius. Article 14.1 enabled an unwed Bahamian mother to step into the shoes of a Bahamian father to claim the Bahamian birthright for her child, subject to the limitations contained in the Constitution itself, and thereby avoid the possibility of the child being considered stateless. So that gives a ratio legis, as it were, an explanation of what the purpose was of Article 14.
And how does that operate?
Well, I think it's so the child is born outside
of a Bahamian woman.
Yes, and the mother can step into the shoes of a Bahamian father to claim that because it's.
How does she do that?
Well, because she then makes the claim on his behalf, is a suggestion.
Because father, where it's illegitimate, means the mother. So you can benefit from the mother's nationality.
Yes.
Otherwise, you wouldn't be able to if it didn't.
So he does add something, Justice of Appeal Isaacs, and then you see the passage straight after that.
Well, that is somewhat unhelpful to you in a way, because it's accepting the starting point in reading the Constitution as a principle that illegitimate children don't count at all.
Well, my lord, our principal argument is, lordships know, we start from the proposition it's biological parents.
I know what you start from, but I'm just pointing out that this
may not be
helpful point from Justice Isaacs may not be quite so helpful after all.
My lord, delete that in that case. I'm sorry to have been. Can I then? So, my lords, those are the submissions we make on the just ordinary principles of construction. We do also say that this is a constitution, that the broad and purposive construction is required that gives full effect to the rights. And if one looks at that principle first enunciated in Fisher at tab 10, in the bundle of authorities, you have it at page 719D. So 719D in Fisher. This is the principle of eschewing the narrow approach of tabulated legalism and taking a broad and purposive construction, not like interpreting a will or a charter. Now, my lord put to my learned friend the point. This is interpretation of the Constitution as a whole, and there's clear support for that, because if one looks at 719A, where therefore it has come to interpret the subsequent provision, chapter 1, whether the premise fundamental, those provisions are to be construed in the manner and according to the rules which apply to acts of Parliament is sound. And then they take two approaches. One is the extension of the conventional approach, because it's only a presumption, but a rebuttable presumption, that it's limited to legitimate children. And then the second would be more radical. This is at C. It would be to treat a constitutional instrument such as this as sui generis, calling for principles of interpretation of its own, suitable to its character as already described, without necessary acceptance of all the presumptions that are relevant to legislation of private law. And then it goes on, their lordships prefer the second. This is in no way to say there are no rules of law which should apply to the interpretation of a constitution. A constitution is a legal instrument giving rise, among other things, to individual rights capable of enforcement in a court of law. Respect must be paid to the language which is used. But then it's quite consistent with this and with the recognition that rules of interpretation may apply, to take as a point of departure for the process of interpretation a recognition of the character and origins of the instrument, and to be guided by the principle of giving full recognition and effect to those fundamental rights and freedoms with a statement of which the Constitution commences. And that's the approach they adopt. Now, to the extent that my learned friend suggested that approach is confined to the interpretation of the human rights provisions in Chapter 3 and analogous provisions in other constitutions, that's not what Fisher says, and it's not what subsequent cases such as Reyes and Bowe say. It's because it's a constitution, and it's because the constitution framers have chosen to include these rights not in an ordinary nationality act, but in the Constitution itself, that one adopts the broad and purposive approach. And my lord, so we do submit that it's wrong to say, as my learned friend seeks to say, oh, well, that approach, the broad and purposive approach, which Winder did adopt, Chief Justice Winder did adopt, is confined to the interpretation of Chapter 3 the entrenched rights provisions.
You can't make the last 2 points that Wilberforce makes, though, can you? That there's no reference anywhere in the Bermuda to legitimacy or illegitimacy.
No,
Nor the point that we're dealing here with provisions in which it can't, in which to distinguish according to where people are born, it would be contrary to fundamental principles.
Well, except insofar as citizenship in Part 2 impacts on the freedom of movement provisions in Part 3, that's to say Section 25, so and Section 15. So
does it also impact on Section 11 or not? The right to belong, that is the right to enter Bermuda and immunity from expulsion therefrom. Does citizenship give you the right to enter Bermuda?
Yes.
Does it?
Yes, if you're a citizenship, yes, you're a citizen, yes.
Okay, and then Section 25.
What's 25? What was that?
Can I just take you to, so if you go to the Constitution, so we've got page 563, the first bit is the protection of law in the preamble, which does have some effect of law, whereas every person is entitled to fundamental rights and freedom. And then if we go to Article 25, except of his consent, no person shall be hindered in the enjoyment, this is 574, enjoyment is freedom of movement. And for the purposes of this article, it said freedom means the right to move freely throughout the Bahamas, the right to reside, yes, my lord, so there it is, at Article 25(1), right to enter the Bahamas, the right to leave. And then there are restrictions which are authorised under 25(2)(d) for those who are not a citizen of the Bahamas. So if you are a citizen of the Bahamas, then you have, as it were, inalienable rights to enter and to leave. And
that doesn't help you, does it, in deciding who is or isn't a citizen?
Well, it may help in whether one adopts the generous interpretation if it's going to have those effects, that it would restrict those rights. My lord, the first point I respectfully make is, if one looks at the various enunciations of the Fisher Principle, the Fisher Principle is not confined to the Chapter 3, but to the status of the Constitution as calling for that interpretation. I can give you another reference. It's in Lord Bingham in Reyes.
Could you take us to that? Because
yes, my lord. Yes,
assisted by that.
Yes, my lord. Lord Bingham, in the case of Reyes, my lord, that's at paragraph 26 of Reyes, and that is at 774. So he talks about, at paragraph 26, page 774, my lords, whereas here the enacted law is said to be incompatible with right protected by the Constitution, the court's duty remains one of interpretation. And then it deals with the whole question of constitutional interpretation. And I accept that the right in question was the right to be free from cruel and unusual punishment. So it was one of the entrenched rights. But it is unnecessary to cite authorities at length because the principles are clear. As in the case of any other instrument, the court must begin its task of constitutional interpretation by carefully considering the language used in the Constitution. But it does not treat the language of the Constitution as if it were found in a will or a deed or a charter party. So it's just that the reference is to the Constitution as a whole, not to just that part of it which protects fundamental rights. A generous and purpose is to be given to constitutional provisions protecting human rights. That's right. But he's already said you don't approach a constitution like you approach the terms of a will or a deed or a charter party in relation to the Constitution as a whole. And I think the same can be said in the case of Bow, where which you have in the supplement in the additional bundle of authorities, another judgment of Lord Bingham at this time in Bahamas. And in that case, Lord Bingham refers to the interpretive principle at paragraph 28.
Is this the appellant supplementary authority?
Yes, our supplement.
So no,
I'm sorry, us, yes, us. I keep thinking of myself as a member. But when I respondent, my lord, yes. Do you have...
Yeah, they've got the additional authorities, yes. Bow, thank you. Got it.
Yes.
Page?
So again...
Which page, sorry?
15, my lord, para 28. After citing a series of cases, including Reyes. Again, I accept it was interpreting the fundamental rights, but if you look at the bottom of para 28, it's ordinarily properly when interpreting a constitution to regard it as a living instrument capable of reflecting the standards and expectations of society as these change and develop over time. While the meaning of constitutional provisions does not change, their content and application may, and the judicial task is ordinarily to bring an objective contemporary judgment to bear. That would, however, as counsel for the Crown rightly submitted, it was inappropriate in that case because they were trying to work out what the position would have been under the 1963 Constitution. But the court can see that that's the approach adopted there. So the language used from Fisher to Reyes and to Bow is about the interpretation of the Constitution, and indeed the living instrument doctrine stems from a Canadian case, the case of Edwards, which as it were, was before the fundamental human rights provisions. So it's a principle about the interpretation of the Constitution as a whole, rather than simply that part of it which protects human rights. So, my lords,
Do we have Edwards?
I'm afraid we don't. It's Chandler's in there. Yeah, it's referred to. My lord, we can get it if necessary.
Thank you, if you would, please.
So, these.
Mr. Rowe cited a Hong Kong case that he says goes the other way.
Yes, well, my lord.
I mean, do you have any particular submission about that case? Or?
Well, my lord, we submit that the words are clear in Fisher, in Reyes and in Bow, and those are Caribbean cases it's about the interpretation of the Constitution. And as I think my Lord Legate observed, it's significant that they've chosen to put these citizenship provisions in the Constitution to entrench these notions. So it's not an ordinary act of Parliament. It can't be right to then just say we'll interpret it as an ordinary act of Parliament. We say even if you did, we'd win, but I mean the Chief Justice would be correct. But we do say he was right to say, I will also adopt the approach that gives full effect to rights. My lords,
is the very difficulty of changing a constitution a reason to give it a more flexible approach?
Yes, my lord, absolutely, yes, that it's got to endure for all time, and in order to remove it, you've got to have a special majority. I think it's 3/4 in Bahamas, but anyway, it's certainly more than that. And there's a whole series of provisions you have to go through. So you can't just change it like an ordinary act of Parliament. So, my lord, that would be our respectful submission, that the location of this important right of citizenship in the Constitution, it's described by Justice of Appeal Jones. This is at paragraph 146 of his judgment, page 183, as, I quote, an essential constitutional provision. And we have to give effect to the fact that there was a deliberate decision to locate these provisions in the Constitution, and that calls for the wider interpretation, if that's necessary. My lords, I've made the point that the construction affects the ambit of entrenched rights such as freedom of movement, but also citizenship rights themselves are of massive significance. If we need any help on that issue, there's the Pomachowski case, which we put in our additional bundles, the additional, so my lord, it's the Respondents additional bundle, tab 4, the Pomachowski case, which is, you have ringing declarations about the significance of citizenship, in that case British citizenship, at page 107. Can I take you to paragraph 31D? By the same token, they underline a potential difference in respect between aliens and citizens. Both in international law and at common law, British citizens enjoy a common law right to come and remain within the jurisdiction.
Sorry, paragraph 31,
Yes, paragraph 31, my lord, page 107.
letter
D.
D, thank you.
By the same token, my lord.
Yes, thank you.
Does my lord have both in international law and at common law, British citizens enjoy a common law right to come and remain, and of course that's now enshrined in the Constitution itself. So having citizenship guarantees your right under Article 25 to come and go. British citizens enjoy a common law right to come and remain. Blackstone stated, but no power on earth except the authority of Parliament can send any subject of England out of the land against his will, no, not even a criminal. This passage was cited and approved by Lord Hoffman in Banku. Lord Diplock spoke of the common law rights of British subjects to enter the United Kingdom when and where they please, and on arrival to go wherever they like within the realm. And in Van Duyn, the European Court of Justice, it's a principle of international law that a state is precluded from refusing its own nationals the right of entry or residence, and a necessary corollary of a state's right under the convention, the Refugee Convention. My lord, there's just so that I mean
We even have the Flying Dutchman.
Oh, yeah, yes. Sorry, I forgot about him. My lords, if we go on to paragraph 49 at page 111, Baroness Hale picks up the, as it were, the centrality and fundamental importance of citizenship. The right at the bottom of page 111, the right of a person to enter and remain in the country of which he is a national is the most fundamental right of citizenship. The United Kingdom signed not ratified protocol number 4. Article 3 makes the right crystal clear, but as Lord Bantz has demonstrated, has been part of United Kingdom law for centuries. It is perhaps more questionable whether it counts as a civil right. As originally conceived, this did not apply to the rights enforceable in public law, but that limitation has been steadily eroded, and then it deals with the question of whether, because the question in issue was, did the extradition of a British citizen attract the safeguards of Article 6, and it was held that because it determined civil rights or obligations, it did. But those statements give an indication, as does the express provisions of Article 25, of the fact that this is about a determination about citizenship under the Constitution is a determination about the ambit of fundamental rights. And so we make the point that the interpretation of Article 6 and 14 impinges on specifically entrenched rights, such as the right to freedom of movement in Article 25 and the protection of law in Article 15. And to the point made by my learned friend that, well, that's very well the idea of living instrument and purpose of interpretations infusing the interpretation of some parts of the Constitution, but it doesn't apply to others. We say that the combination of Article 6 and 14 can't be compared to a savings clause. He relies on the case of Siraj, which dealt with the savings clause. If you look at the savings clause, there's no doubt about its interpretation, because it just says, partially arguments to the contrary, but it just says no law passed before independence can be challenged under the Constitution for inconsistency with human rights. That's in the Siraj case, tab 13, paragraph 16, EB 795. So EB 795. And yes, it sets out paragraph 16. You'll see the savings law clause in question in the Trinidad Constitution, and one can see why they're saying that's fixed and and steady. 795A, nothing in section 4 and 5 shall invalidate an existing law. So it's very clear and needs to be fixed. That's what the Privy Council decided in Suraj.
That may be a convenient point, Mr. Fitzgerald.
Yes, my lord, yes.
It may be be able to assist us in relation to the Hong Kong case in Carling at 2 o'clock.
My lord, yes.
Thank you very much.